Welcome back to one more session. In this video, I am going to explain about pleadings and classification of pleadings. So it is general topic. I make it as some more generalized. That is, pleadings are statements in writing drawn up and filed by each party to a case, stating that what his contentions will be at the trial and giving all such details as his opponent needs to know in order to prepare his case in answer. The drafting of pleadings is an art. It demands a high degree of professional skill and professional knowledge, expertise, and experience. It is not a child's play as some young members of the bar fancy. Various works on pleadings and the formats framed by the authors and the forms annexed to the Code of Civil Procedure and other enactments are only a guide, and it is for the lawyers who owes a duty to both the profession and the court to see that the pleadings are properly framed. The function of pleadings is not simply for the benefit of the parties, but also and perhaps primarily for the assistance of the court by defining what precision the area beyond which, without the levy of the court and consequential amendment of the pleadings, the conflict must not be allowed to extend. While a lawyer is entitled to set out the case of his client clearly and firmly, he must not forget his duty to the profession to which he belongs and throw away the noble traditions of the bar and use intemperate or vituperate epithet or make scandalous, frivolous, vexatious allegations against the opponents. Not infrequently, such allegations land the counsel himself in trouble. The typical instance is the use of the word avara against the plaintiff's son in the written statement has led to series of litigations involving the counsel for the defendant. Moderation in language is the hallmark of proper pleadings. The court is not expected to be a mute spectator to the pleadings raised by the parties. It is the duty of the court to peruse the pleadings at least at the time of framing of the issues and strike out the matters which are unnecessary, scandalous, frivolous, or vexatious, or which may tend to prejudice, embarrass, or delay the fair trial of the suit, or which is otherwise an abuse of the procedure of the court under Order 6, Rule 16. At the same time, the court should realize that the rules of the procedure of which pleadings form but a part are matters of the mere machinery for rendering justice. Its approach should be a pragmatic and not highly technical. It must be borne in mind that the rules of pleadings are intended to regulate the business and procedures of the court. They never create new legal rights where none exist, nor do they take away the existing rights. The Code of Civil Procedure is only an adjective law as opposed to substantive law, on the basis of which alone the rights of the party are to be determined. The primary duty of the lawyer is first to make himself familiar with the substantive law on the subject on hand, statutory, customary, and judicial precedents up to date, to find out the correct position of law on the matter in question. To ascertain where his client stands, and then shape the pleadings according to law to the best advantage of his client. This is much more important in the case of budding lawyers, many of whom have not even taken the apprentice course under the seniors. A lawyer through his profession must have the mental stamina and intellectual honesty to lay bare before his client the correct legal position, inform in appropriate cases of the fertility and frailty of his case, and advise him accordingly. An honest lawyer who gives an honest opinion at the risk of losing his brief as bound, in the long run, to earn the confidence of the litigant public. It is the first and foremost duty of a lawyer brief to file a suit to consider whether the subject matter of the suit of civil nature and is maintainable in the regular court of civil jurisdiction. Section 9 of the Code of Civil Procedure lays down that courts shall, subject to provisions herein contained, have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or implied barred. If a civil court has no jurisdiction to try the case, it goes to the very root of the jurisdiction, and it is a case of inherent lack of jurisdiction. We may classify pleadings under four broad heads, that is, pleadings in suit, pleadings in other civil proceedings before a court or a tribunal, pleadings in writ proceedings, pleadings in an election petition. Thank you.